Thank you everyone for joining us and welcome to this webinar. We're hosting this webinar together jointly with Suomi Seura, and we have advisor Jenny Orphanou representing Suomi Seura. I'm Maria Voltaine, and I'm the operations manager for Finlandia Foundation National. We have two subject matter experts here today, a New York-based Ann-Christine Westerlund from West-USA Inc. and Helsinki-based Anne Nikula, or Anne, from Nikula Legal. Anne and Ann-Christine will discuss various aspects of these complicated issues regarding inheritance and taxation. However, in situations where the answers are going to be very case-specific, we recommend contacting a tax advisor directly and work with them. Both ladies can be reached out to if you would like to work with them, and their information is going to be in the presentation. And the presentation will be emailed to you separately after this webinar. So let's get started. First, we will hear from Anne Nikula, CEO and founder of Nikula Legal Law Office. With more than 30 years experience in law and tax-related issues, Anne Nikula provides advice and counsel to individuals and companies with a particular focus on wealth planning and in all aspects of tax matters. As a tax attorney, Anne has assisted her clients in transactions, estate planning and administration, shareholders agreements and business contracts, etc. Before reactivating the law firm Nikula Legal in 2018, Anne was employed in the tax administration as a senior auditor specialized in corporate taxation and international tax matters, and later in the banking sector as a senior counsel specialized in wealth planning. In the 1990s, Anne provided advocacy services to entrepreneurs and individuals in general law, company and tax cases and damages. After the practical training on the bench, she was granted an honorary title, Varatuomari, MLL with judge's qualification in December 1991. And after Anne's presentation, we will hear from Ann-Christine Westerlund, CEO and founder of West-USA Inc. It started with Stevie Wonder. The global superstar performed in Finland in 1984, and Ann-Christine Westerlund of Ernst & Young Helsinki was assigned to determine whether Mr. Wonder was obliged to pay taxes in Finland. Ann-Christine was first a partner at Ernst & Young Helsinki from 1986 to 1990, and then in New York from 1990 to 1993, after which she founded her own company, West-USA Inc. She has a deep understanding of both Nordic and US tax regulations, and her fluency in English, Swedish, and Finnish make her the West-USA team uniquely qualified to handle US tax returns and US Nordic tax-related questions. A leading light in the Nordic community in New York, Ann-Christine is an active member of leading Nordic American professional organizations and the International Taxation Committee, New York State Society of CPAs. A lover of sport and the outdoors, Ann-Christine has completed numerous marathons and half marathons, including the New York, Helsinki, Stockholm, and Rotterdam marathons. And without further ado, Anne, the floor is yours.
Well, hello, everyone. Can you hear me?
Yes.
Yes. Okay, good. Well, thank you for inviting me to this seminar, and I welcome you all who are online. I talk issues related to succession law and compare the US system with the Finnish system. Well, I was introduced, so I go to the timeline. Thank you. The timeline of succession matters includes the anticipation and preparation period that is one of the most important periods when you think about your succession and your inheritance issues. Estate inventory stage starts immediately after the death of the deceased, and finally the estate administration that may go on for years. Estate planning should be done in good time and when you are still capable of doing things yourself. One of the things I haven't listed here is a durable power of attorney to be used in case you get seriously ill and are unable to take care of your matters yourself. A durable power of attorney is a document to be used so that your financial matters don't get messed up. If you are living in the United States, you should consider drawing up a document including information about your family and about yourself. It's so-called genealogy. And it would be great if this document could be certified by a notary. And I will explain you later why you should do this. To make preparations is also to consider whether to make a will or whether to create a trust. So to plan and manage inheritance issues is to go forward step by step. Estate inventory days is a period that starts after the death, and it lasts about 1 month or several months, perhaps even years, if the estate is disputable. And during these days, the deed of estate inventory is constructed, and it's a very informative document about the person who has passed away and about his estate. In Finland, according to the law, the deed of estate inventory must be prepared and undersigned within 3 months after the date of death. This 3-month time limit can be extended if need be. And during this period, the assets of the deceased are frozen. The banks don't know with whom to deal, who is entitled to deal with the assets. And that's why the estate administration needs to be organized. The deed of estate inventory specifies the beneficiaries, the assets and liabilities. And during the estate inventory stage, the foundation of the estate administration is created. So a deed of estate inventory is a list of persons who are linked to the estate. In Finland, the children inherit by law, and the surviving spouse doesn't inherit or inherits only if there are no children. In Finland, family relationships are registered by the Digital and Population Data Service Agency, the former magistrate. And these official certificates are required for the estate inventory. If you are residing in the US, it's recommended that you draw up a certificate similar to these family records or genealogy, and it would be good to have it notarized. It's a proof for the banks and authorities about the inheritors by law. If the inheritor or beneficiary is residing in the US and the deed of estate is done in Finland, a certificate of life or certificate, affidavit certificate is requested to prove that the person is alive. And this document can be acquired from the Embassy of Finland or the consulate or from a local public notary. The estate inventory deed includes also other documents like the last will, the prenuptial agreement if there is one, bank statement, and so on. And it takes time to get these documents. And that's why it's recommended that everyone keeps a file where the information can be found. In Finland, it's important to ensure the persons who are entitled to inherit by law, because according to the law, every child has the right to inherit, and every child has the right to claim for a reserved portion. So a part of estate is reserved for the children, and a part of the will is null and void if the child claims for his reserved portion. The system how to validate a will is different in these two countries. In the US, there is a specific probate proceeding to determine that a will is valid. In Finland, a notice of a will is given to every inheritor by law, and the will becomes valid and enforceable after 6 months if no one disputes the will. The will can be contested and the case can be taken to the court if it can be proven that the testator was making the will under force, or if he was incapable of making a will because of his state of health. So in order to validate a will, all inheritors by law must be known. And I talk about these family records and how you should try to make some kind of certificate yourself if you are in the United States, because I am aware that in some cases a person has lived in the United States for about 20-30 years, moved back to Finland, and then passed away. And if there is a gap in official certificates, and if there is a possibility that the deceased could have had a child in the United States, the bank may refuse to give the assets in the bank account to anyone. And that's why I recommend that you should have your own family records created somehow. This kind of documentary is important if there is any registered property like land, or if there are assets in a bank or investments in an investment company. Anyway, the deed of estate inventory is also a tax declaration, and it must be submitted to the tax office within 1 month after it was undersigned. The tax office will check out the persons who are involved and also the values of the property. And there is a place for tax planning in considering the values of the property. It's also worth thinking about the future steps, whether you are going to sell the property or whether you are going to keep it. It's good to know that the tax on selling profit is higher than the inheritance tax. So you could plan your taxation in advance. After the inventory stage, the estate is somehow defined, and we should know the persons involved and their rights and obligations. The estate administration corresponds to joint ownership. The inheritors and beneficiaries constitute the estate administration, and all decisions concerning the estate are made jointly. The surviving spouse may be involved in the estate administration if she has any marital rights concerning the property, or if she is a beneficiary in a will. If there is no prenuptial agreement, marital rights and the position of the surviving spouse must be sorted out before the estate can be divided by the inheritors and beneficiaries. If there is a dispute concerning the estate that cannot be settled in an amicable way, the party may take the case to a court and apply for an administrator to be nominated. The administrator appointed by the court has the capacity to make independent decisions, and he has the power to divide the estate and distribute the assets to the beneficiaries. In taxation, the estate is a separate entity. It may sell property, it may buy property, it can take loans and make investments, receive incomes, and the estate should give annual tax declarations. The estate may go on for years, and it may be divided partially, so that part of the assets are taken out of the estate and the rest remains. In case all estate property has been divided and there is nothing left, the tax authorities should be informed. Otherwise, the estate remains in the tax records, and you should get tax declaration forms year after year. Next slide, please. US trust in Finland are accepted. The assets in a living revocable trust are treated as assets of the grantor, and the grantor declares the dividends and other trust incomes as his own income in taxation. So if you are a tax resident in Finland and you have a US living trust, you declare your capital income in Finland. Also, irrevocable trusts are regarded as separate entities, and the assets are not the assets of you. As far as I understand, irrevocable trusts are separate entities also in Finland. However, there is no such corresponding system as trust system in Finland, and that may cause some confusion. A certain investment insurance arrangement during your lifetime could be regarded as a living trust in Finland, or you could set up a foundation and separate certain property from your estate. But you should also consider the legal costs and running expenses of all arrangements. There may be tax consequences related to transfer of property into a trust. So every trust arrangement should be studied and considered case by law. There is the estate tax treaty or inheritance tax treaty between the United States and Finland, and it is to be applied to bilateral situations. If the deceased person was a resident in the US and his estate is located in the US, there should be no inheritance tax paid in Finland. The inheritor in Finland should pay tax only on property located in Finland. If a beneficiary who is living in Finland receives payment from a US trust, the banks and financial institutions are required to ask about the origin of the money transfer because of the anti-money laundering legislation. And for this purpose, the beneficiary in Finland should be prepared to present trust documents to the Finnish authorities. In managing cross-Atlantic inheritance issues, a combination of a will and a trust might be recommended. I have learned from a couple of US lawyers that it's not recommended to include a foreign real estate into a US trust. And I can understand that because the trust administration becomes more complex if there are foreign assets and incomes from abroad that you should declare in Finland or elsewhere. So you should always consider the practical things, what is needed to administer your estate and how much it is going to cost you. And also consider the financial position of your spouse and children and grandchildren. What do they need? If you make future plans, you should take into account the inflation and the rising living costs. In Finland, a will is probably the most common way to organize one's inheritance issues. If you have dual citizenships, both US and Finnish, you can select the law to be applied to your estate after your death. So even though you have property in Finland, you can order that the succession law of Florida or California or New York is to be applied to your estate. This is a way to avoid confusion concerning the applicable law and also whether the child has the right to claim for his reserved portion or not. In Finland, according to the law, the surviving spouse has the right to live and stay in the house or apartment that has been the home of the spouses. In a will, you can make more flexible arrangements than what the law offers. And you could do some estate planning to keep separated the ownership right and the right to use the property is to keep the inheritance tax lower. The usufruct may reduce the value of property for about 20 to 50%, depending on certain factors. The usufruct is also used as reins to hold the property in one's hands in order to hinder the younger generation from selling the property or wasting it. A will concerning the property in Finland can be made in the United States. It's important that you ensure that your will is enforceable document, that it's a reliable document. And that's why it's advised that it should be notarized. A US will is recognized in Finland, and you have to present the original will if you claim your rights. And that's why many lawyers recommend that you should have two separate testaments, one for the United States and one for Finland. If you make two separate wills, it's important to note that the wills amend one another, because according to the law, the last will nullifies the previous ones. In the US, there is probate to determine that a will is valid. In Finland, a notice of a will must be given to every inheritor. For practical reasons, it's important to be able to prove by documents who are the surviving spouse and who are the inheritors by law. Okay, let's go to the next slide. The estate tax agreement between the United States and Finland is to be applied to US-Finnish inheritance situations. And when a beneficiary resides in Finland and inherits something from the US, he should declare the inherited property to the Finnish tax authorities. However, Finland has no right to levy inheritance tax if the deceased person was a resident in the United States and the property is located in the United States. So Finland shall levy tax only on property in Finland. When a beneficiary resides in the US and the estate is in Finland, the deed of estate inventory is submitted to the Finnish tax authorities, and the inheritance tax should be paid on property in Finland. The international inheritance tax issues have been difficult to deal with in the past. The tax treaty was made in 1952, and the local authorities often tend to apply the local laws. The international tax treaties require special knowledge, and the tax practice in Finland has developed through the case law. I was employed in the tax administration, and in 2010 it was quite common that a US trust was regarded as an inheritance received by a Finnish resident. At the moment, Finnish authorities accept the president of the Supreme Administrative Court, that was given in 2014, and according to this decision, the US estate of a US resident is taxed only in the United States. Next slide. There's estate tax in Finland. I took just some examples. In the US, you talk about the estate tax as the tax is levied on the estate. In Finland, we talk about inheritance tax. The person who inherits is liable to pay a tax. And the lowest taxable legacy is 20,000 euros. And this chart is just to give you a picture of the level of the Finnish inheritance tax. I'm not going to go through it in details, but this PowerPoint is available to you if you ask for it. The surviving spouse receives a tax deduction of 90,000 euros, and the legacy below 20,000 euro is not taxed at all. So if the surviving spouse inherits 110,000 euros, the tax would be 100 euros. So I end my presentation here, and thank you for your interest, and I let Ann-Christine to continue.
Hello, everybody. I'm going to talk mostly about US taxes because that's what I'm doing. And first about the inheritance tax in the US. So the biggest difference between the US and Finnish tax, estate tax, is that in the US, the estate is subject to tax, and in Finland, the inheritors are subject to tax. So the tax in the US, the estate tax is paid from the estate itself, but in the Finland, it depends on how close you are related to the person who passed away, and it's a different percentage according to that. And as we already heard, there is a estate tax treaty between Finland and the US from 1952, and it only applies to estate tax, not to gift tax. And in the US, the US citizen and US persons domiciled in the US are subject to the US estate tax and gift tax. And there is, as you know, a huge exemption amount, 11.7 million for 2021. And it's only if you have more than that in your estate that you pay taxes, which is starting from 18% to 40%. The rate is progressive. And this is 11.7 is most likely going down now. According to Biden's suggestion, it would be something like 5 million, but still quite a lot. So, and the domicile concept is only something what you use for for estate in the US. Otherwise, you talk for income tax about resident. So it's a different definition of what is domiciled and what is like resident. You are like domiciled usually if you have green card, and then if you live permanently in the US and your children are there, and everything is mostly located for you in the US, and you don't have any purpose to move back to Finland or any other place. So, then you are considered domiciled in the US, and it means that you are subject to US estate tax on your worldwide assets at the same way as for US citizens. So there is a test for that, and for the resident, if you have income tax, then it depends on the days, but here it doesn't depend for the domicile about the days. It's just how close related or how you that you really live in the US and no plans to move from there. That's the domicile concept. And then for non-US people not living who are not domiciled in the US, so they are subject to US estate tax on certain assets, and the tax rate is again like from 18 to 40%, but there is a 60,000 exemption only compared to 11.7 million if you are US citizen and US domiciled. Then the next slide, please. And then in the US, there is an unlimited marital deduction, which means that assets left to surviving spouse are not subject to federal estate tax, no matter how much they are worth. The surviving spouse has to be a US citizen. So then you don't pay any taxes if you get it from the spouse who passed away. It's unlimited, this marital deduction. If the spouse is not a US citizen, for example, has a green card, then this marital deductions is not allowed. So that's very important to know, that if the spouse has a green card or a visa or something, you cannot get this unlimited marital deduction. But then there is a way to set up, you can defer the US tax for assets passing to non-US citizen spouse if the US property passes through a qualified domestic trust. So you should set, in that case, you should set up a qualified domestic trust. And this way you don't have to pay taxes when your spouse passed away. Then I want to talk about what happened if you get inheritance from Finland and you live in the US. In this case, the inheritance is only taxed in the US. No, sorry, only in Finland, and it's not taxable in the US. But it has to be reported in the US. That's very important. It has to be, if it's more than 100,000, and it can be like totally 100,000. It can be both real estate, it can be shares, it can be bank accounts. But if it's more than 100,000, you have to report it on a form called 3520. And it's reported at the same time as you file the 1040 tax return. So it's like an attachment to that tax return. And what you have on this form, you have to report, like say the date when the person passed away, and each assets which is more than $5,000, you have to specify that it's like money, or if it's a real estate and where it's located, you have to make a list of that, and then also what the fair market value is at the time you received it from the estate. So and the thing is that if you don't do this report, there is very high, it's an information report, but it's a very high penalty. It's like $10,000, or it can be more depending on the value of what you receive. So you should, it's very important to do it, not to pay these penalties. Next slide. And then the other way around, that you get inheritance from the US when living in Finland. So there is, for example, a non-US citizen, non-US, not domiciled in the US, passed away in Finland and has US assets located in the US. So then you have to file the tax reform, this 706 NA in the US, and for what you have there, for example, usually it can be investments and so, and you have to, if it's more than $60,000, the value of it, you have to report it, and it has to be done 9 months after the date of the death, and unless, and you can ask for an extension for 6 more months, and what you have on the tax return, this 706, you have to report both the US gross estate, the estate in the US, and the gross estate outside the US on separate lines. So everything has to be reported in the US. And it will also be taxed from 18 to 40% after a deduction of a $13,000 credit. I think that was what I had mainly, but I would like now to answer some questions I already went through. I think that wasn't this the last slide, or I have some questions I already went through and I want to comment on them, and then maybe for the rest, Anne can then respond what is not really my. So the first was from, just a second, it was from.
Let's just use first names, by the way. Let's just use first names.
I just have them by last name. That's a problem.
Oh, okay. There you go.
Okay, so there was from Taylor. He asked about U.S. shelter and financial assistance to the daughter. Regarding the financial assistance to the daughter, there is not so much you can really do in Finland. You can give like $5,000 as a gift every third year. So that's what you can do, like So I cannot now at least think about something else. And I don't really know about what you mean by US shelters and what kind of assets you have in the US. So if you like, you can contact me later, but I don't really want to answer that because it's not really clear for me. And then Lena Scott asked about what need to be reported in Finland when you live and you are a US citizen in the US. That's, I understand, mostly like not related to estate, but so generally if you have a house or an apartment in Finland and rental income, it has to be reported in Finland. And then if you have dividends and interest has to be reported. So mainly what kind of income you have in Finland has to be reported in Finland, except like capital gains from shares. According to the tax treaty, it's only taxed in the US when you live in the US. And then, of course, if the bank accounts is very important. I forgot to remember that when I spoke about this 3520, that the F-bar is very important, because usually when you inherited something, you will have more than $10,000 on the bank account in Finland, and then this has to be reported on the F-bar every year you have. And it's only so, for example, that if you have 5,000 on one bank account and 6,000 on another, it's counted it's counted as more than 10,000. And that's during the year, it's not by the end of the year. So you have to go through and see, did you have together this more than 10,000? And then in that case, on the F-bar, you have to report the account number, the maximum amount, and the name of the bank and the address. And it's reported at the same time when you file the tax return in the US, but it's a separate report. It's because it's separately reported. And then Pulkkinen asked about he's moving to Finland, and he has investment in the US, and he's wondering what's happening to them. And the thing is that if you have IRAs or 401ks, I strongly recommend that you take out the distribution and invest it in another way, because otherwise it will be taxed as income. And they now also have new regulations in Finland that they will tax as income in Finland, the IRAs and the 401ks as ansiotulo or like income, and it's much higher taxed in Finland than in the US. So therefore, if you have them and you plan to move to Finland, you should take them. You should already invest them in a different way in the US. And also like Roth IRA, which is not taxed before, it's also maybe good, because in that case it will be taxed as pääomatulo in Finland, and it's much higher than the capital gain in the US. So that's good to think about. And the same applies to Bauder or Border, also asked about how to transfer finances. So it depends what kind of finances you have. I mean, if it's just money, you can transfer them without any problem. Just you transfer them to Finland. But if also you have to remember that when you live in Finland, you cannot anymore actively trade with a US broker because of this money laundering regulations. And so you should check with the brokerage firm. Sometimes they allow you to do for some time or some transactions, but generally you cannot continue to do trading with stocks when you live in Finland regarding what you have already in US. I mean, you can buy US stocks in Finland, but not with the account you have in the US. So you should also give that some thoughts, that if you should sell the shares in the US and then transfer the money to Finland. And then Howell asked about that she has a if she dies in Finland and the daughters are in the US, what happened? So the thing is, yeah. So in that case, this the daughters pay the taxes to Finland, and then they have to report this on 3520 on the tax return as an information, as I already spoke about. And also, Mogavero asked about the inheritance tax, that she has paid the inheritance tax in Finland, and then she plans to sell the house in Finland, and she doesn't. Of course, she doesn't pay any U.S. inheritance tax in this case, but she has, again, it has to be reported on 3520. But if she sell the house it depends then on the value of what it has on the estate in Finland and how much she gets when she sells it. If there is like a capital gain, then she has to pay taxes on that in Finland. And it also has to be reported in the US, and she has to pay taxes also in the US, but she will get tax credit what she has paid in Finland in the US. And in many times the taxes are higher in Finland, so you don't really pay any more taxes in the US. So, and then Aaltonen asked about they are moving to Finland, and they have a sole LLC, which is taxed on 1040. And how it will be taxed? It will be taxed in Finland because then you will be a resident in Finland. It's not anymore taxed in the US, and it's taxed in Finland. But you have to remember then that in Finland, you cannot file joint tax return. It's separate tax returns. So I don't know if you share this LLC or if it's only for one person, but it's taxed in Finland and you are taxed separately. And then Mäkipää asked about that he has a friend. She has quite a lot of estate in the US. She lives in the US, but she would like to give part of the inheritance to her cousins in Finland. But then when he informed her that she has to pay taxes, they have to pay taxes in Finland, they came up with the idea to instead to have buy a vacation home house in Florida. And the question was if then there is any taxes. And I think this could work quite good because then there is no transfer to Finland, so they don't have to pay anything in Finland. And in the US, because of the state tax is very high anyway, so there will not be any taxes. So it could be a good idea to buy this house in Florida, and then they could inherit it. The cousins could inherit it without paying any taxes. That's what. Of course, you have to know all the details because you can't be very clear, but that's what I feel. And then Langbein asked about this 3520, like if it makes a difference if it's shares or bank account or you own some land. No, you only have to state them in the US, but it doesn't make, everything has to be stated on this 3520, but you don't. It doesn't make any difference. So okay, so that's what my question, what I could answer on the questions.
Wonderful. That's been so helpful. I learned a bunch of things myself. I had no idea. So this has been very, very informative. And we have a wealth of questions. This is why we have these experts here to share, but also really for a particular situation, it's important to go to somebody who is an expert in whatever field, because there's several different aspects of, there's the real estate, there's the stocks, and there's the all sort in cash and what to do with the different amounts and all those kinds of things. So this is a very, very complicated matter. So thank you, Ann-Christine and Anne, and also Jenny from Suomi Seura. Thank you so much also for answering a lot of those questions in the chat. We will be sending this presentation to everyone and uploading this to YouTube, so you can refresh if you'd like. And please do reach out if you have further questions. And I wish you much success with your estate planning.
Thank you very much, Maria, for hosting the evening, and thank you for the experts from me as well, Anne and Anne-Marie, and thank you for all the participations taking part. Please reach out. You're welcome to visit our websites and follow us, both Finlandia Foundation and Suomi Seura, on our social media and on our websites, and contact us by email or telephone.
Absolutely, we'd love to hear from you. So with that, I'm going to say goodbye for now and see you in our next webinar.
Thank you for all, and good night, and have a nice day.
Yes.
Thank you.